Yeah, all ready if you are?
Yeah.
Okay, cool, no worries. Morning, everyone. Hope everyone is well. And you had a fantastic weekend. For those of you who don't know me, I'm Gary Richards. I'm the Group Operations Director for GAP Personnel. And on behalf of GAP Personnel and the team, I'd just like to sort of welcome you to today's webinar. I know many of you will have been on many of the sessions that we've ran in partnership with Aaron Partners for many years now, actually. We've run a number of these sessions, and obviously it's a truly sort of valued relationship that we've got with Aaron Partners. Basically, you've got the format. It is going to be a Q&A, and we've got a number of questions that have been sent in already, which I'll be going through, and Paul and Adam will be answering your questions through today's session. So on that note, I'll pass across to one other point is you can put any further questions that you've got into the group chat as well. I think it's already been mentioned on there, so feel free to put any sort of questions you've got posed through the session today. Paul, pass across to yourself.
Thanks, Gary. Yeah, welcome everybody, and thanks for joining us today. Some of you, as Gary touched on, will have attended these types of events before, and we don't want to waste too much time doing intros. But I'm a solicitor and senior associate in the employment team at Aaron and Partners, and I'm going to present today with Adam Haynes, who's a partner, and also Natalie Howard, who's not got a camera on, but is going to be manning the chat facilities today. So, as Gary said, pop any questions that you may think of as we're going along, and we'll try and cover them out. We have got an awful lot to get through. COVID is obviously something that changed all of our lives, and for those of us who deal with employees and HR, there's certainly it certainly was a considerable number of legal issues, and we've been working hard to advise clients through the pandemic on those points. I think two of the things that are going to come out today really is the GDPR risks and the risks of potential claims that you may face if you challenge staff on vaccination status. But yeah, as I say, we better get into the nitty-gritty because we have got a lot to get through. So yeah, Gary, if you want to start off with the first question, great.
No problem. First question is mandatory vaccination. What is the statutory position?
Okay, so this question is sort of in terms of general, not just in the workplace, but in everyday life. And there is actually currently no legislative power for the UK government to mandate that people get the vaccine. Whilst obviously it's highly recommended, and the government is clearly recommending that everybody gets vaccinated, and we're seeing that now progressing to sort of secondary school aged children, because they see that the best way to fight coronavirus and for allow us to get back to normal life is to rely on the vaccine, and hopefully the infection rates and certainly the consequences of getting COVID are seriously diminished by getting jabbed. But fortunately, however you see it, there are too many difficulties, I think, really legally, arguably morally, and the human rights angles. That's just to make it's too difficult to sort of have a mandatory vaccine. Everybody must be vaccinated. It's just not going to happen. And so whilst all we can do is rely on a recommendation and guidance. In terms of the workplace, most of you will be aware that it is becoming mandatory on the 11th of November for staff who work in care homes to have been double jabbed. Obviously, the time it takes to get double jabbed is, I think the minimum period is 8 weeks. So we are now, that date for getting the first jab was in September and has now passed. And so we are rapidly approaching the date on which care home workers who haven't been vaccinated maybe find themselves unemployed because they've made the decision not to get the job. There is legislative guidance on not requiring people to go under any medical treatment, which does include mandatory vaccinations. But obviously, the way I think the Conservatives are seeking to manage that is by placing restrictions on what people who are vaccinated can do in terms of movement. If you think of the sort of examples of, when you go on holiday, if you've been double jabbed, you don't have to quarantine from what were amber list and green countries. Now, then obviously, if you haven't been double jabbed, then you have to spend a period of quarantine. So that's the position. As I say, there's no legal requirement or mandatory requirement to vaccinate people, and I don't think it's going to be. But obviously, that doesn't necessarily solve all the workplace issues. So Adam's going to touch on that now.
Okay. Adam, next question for yourself, actually. Can an employer ask whether a candidate has been vaccinated as part of its recruitment process?
Thanks, Gary. Typical legal response of potentially. I'm going to sit well and truly on the fence, but I'll go around some of the issues and things to consider in relation to it. So the first issue that it potentially causes is in relation to data protection, GDPR. So you may want, for example, proof to track staff on vaccination levels, assess risk of transmission, assess eligibility under any form of a vaccination incentive scheme that you're running, and ascertain whether individuals are required to self-isolate if they haven't been vaccinated. So because we're requesting that information, it comes under a special category personal data under GDPR provisions. So what that puts is an additional obligation on companies that are taking that data to be responsible for it. So you've got to have a lawful basis by which to take it standard, and then a condition of processing. And Paul's going to touch upon it in a little bit more detail later on. So an example is staff, you may look to take that information if, for example, may deem it to be appropriate if staff are likely to come into contact with those infected, or staff who aren't vaccinated pose a risk to clinically vulnerable individuals, because obviously it would be a higher risk scenario and you've got a responsibility to provide a safe working environment to people. However, it's worthwhile noting that if employers are only doing visual checks of whether they've been vaccinated or not recording that information, the Information Commission has said that they don't seem that to be processing of data. So it's sort of quite worthwhile noting that actually visual checks, not noting it down, may be a way of handling and not dealing with it. So it depends on the processes you're putting in place. The other thing to consider off the back of this question is whether, if you're asking at recruitment, whether you're doing a pre-employment health check. So in accordance with the Quality Act, you're not entitled to, well, you're prevented from asking that question. It isn't an offence to actually ask the question, but if you rely upon the rationale, so for example, you decide to not employ somebody because they have a disability and haven't been vaccinated, then that would potentially amount to discrimination. Okay, so you've got to be wary of that. Some companies may make the decision to ask the question and then not rely upon it, and obviously all put in place to justify its position, but I think you'll be going over and above to evidence why this person hasn't got the job. If they do disclose a potential disability or have a race-related reason or a belief-related reason, you're going to have a lot more of a knotty issue than if you're not asking the question. And asking the question isn't an offence, but if you were to get a claim for discrimination to say, for example, I didn't get this job because I disclosed the fact that I have a chronic heart condition, which meant I couldn't be vaccinated, then obviously, as you possibly know, the burden for discrimination cases is initially with the claimant to do the first stage of the burden of proof. And because of asking the question, it's likely to meet that burden. So therefore, it puts a positive obligation on the company as an employer to justify why it asked the question and it didn't discriminate. So what was the justification for doing what they're alleged to have done? So again, I think that question itself is a risk scenario, understanding what the legal knotty issues are, and then making a policy decision internally as to how you want to deal with it. So yes, you can potentially do all of that, but just be aware of the risks to it.
Okay, thank you. Paul, back to yourself. Can employers prevent unvaccinated employees from entering the workplace?
Similar start to as Adam answered, potentially yes, and yes, might get a sore bottom from sitting on the fence. Yeah.
Giving really simple answers to this.
So yes, it can be done, but it needs to be proportionate. So the best thing to do, and we'd advise anyone considering preventing non-vaccinated people from coming to the workplace, is conduct a risk assessment and carefully consider what is appropriate and what is needed and why it might not be appropriate for non-vaccinated staff to attend the workplace. The current government guidance is clear that the vaccination status of a workforce has no impact on the safety measures that employers should follow. But the reason for that is we currently don't actually know whether the vaccine prevents transmission. So does the vaccine stop people catching coronavirus is the question, and there's arguments to say that it doesn't, and that seems to kind of be the view. It's more to do with the symptoms being significantly diminished if you've been double jabbed. Employers have health and safety obligations to employers, and you always need to remember them. And when those staff come to the workplace, you know, you do need to do what you can to keep them safe, and you've got a duty of care to them, of course. And obviously, failing to keep staff health and safety is potentially a breach of duty and can lead to certainly complications. But yeah, yes, you can do it, but you would need to carefully consider the reasons for why doing it. You can't. I wouldn't just be saying, you know, no one who's vaccinated is coming on our site. You need to appropriately document it and think about those things that Adam's just touched upon there in terms of discrimination, GDPR, because it's not just something that can be introduced as a blanket policy.
Okay. Next question is, what must an employer looking to impose a mandatory vaccination requirement do? I think that's to you, Adam. That's
another simple question, but thank you. So first and foremost, we're going to take a really detailed business review and a risk assessment to evidence why COVID vaccination is required, in addition to compliance with the stringent COVID secure guidance in place. So as you would with a redundancy scenario, your rationale for doing this is imperative to justifying your position and the approach you're taking. Okay, so why do you believe that this is necessary? And again, I think of this as a sort of a set of scales. You're making a decision to mandate it because of risk or because of ensuring a safe working environment. But why does that priority outweigh the impact on people's liberty to choose whether to be vaccinated or not? So it's that sort of scenario that you've got to have a robust rationale for it. So this is going to be key to dealing with it. Off the basis of then considering those points, then it will be going to staff, employee reps, employee reps and trade unions to consider consultation in respect of it. Okay, depends on your scenario as to who those people you're going to have to go to, but go to them to obviously explain what your policy you're proposing to implement and get people's engagement response to that. We were talking offline beforehand about we've seen a real mixed response from employees as to this sort of consultation. Some companies are finding that employees are really positive about this, and that actually may be a help, because I think if you're looking to the legal issues I'll deal with later, that's the risks involved, you're getting engagement and you're getting positive response, then I think that further helps your business rationale, because you've got the employees behind it, and that should help you move forward with it. If an employer is unable to provide sufficient justification for it and the tribunal was to decide that it wasn't a robust reason, then you're exposed to risks of claims for unfair dismissal, constructive unfair dismissal, if you put in place the mandatory policy, and discrimination claims that may be on grounds of race or belief, obviously disability discrimination, and potentially on grounds of age as well. There are coverage in the media about certain younger groups maybe not taking up the vaccine for various reasons due to the unknown consequences of it, and potentially even sex as well, because of the stuff around potential impact on fertility. So it's again just being alert to that and maybe making exceptions in certain scenarios. One of the reasons you might allow a mandatory policy for certain groups is if there's travel overseas, whereby there is a requirement for visitors to be vaccinated on entry. So that may be a situation maybe easier to justify. And again, just areas to act within caution if you're looking at this, and areas to consider is obviously the European Human Rights Commission warned that a blanket vaccination policy applying inflexibility is likely to be unlawful due to vaccination not being suitable to everyone. So again, looking at the policy, you might want to consider those things and consider flexibility within the policy. Risk of repudiatory breaches is discovered and constructive unfair dismissal. Potential for indirect discrimination because of the groups we just covered off. The point Paul discussed about what extent does the vaccination actually stop transmission, and how long is it actually following vaccination, is it going to actually be effective? Negative publicity, a lot of the media are picking up on policies such as this, and whether that's something you want to court, and then obviously the data protection implications. So those are just things to consider.
Okay, thank you. An interesting question next. It's for yourself, Paul. Can an employer make an offer of employment conditional on proof of vaccination?
So our view is yes, they can. The government has said they will not be taking any action against businesses to prevent this approach. That obviously ties into what I said at the start about there being an encouragement for people to vaccine, and that being deemed the best way to fight COVID. That's not to say it's not without risk, and I'll talk about them now. So you will have seen, those of you who've been going to either football or concerts. I think Gary said he went to a comedy show or something like that, and there's a requirement when you actually book the tickets that it says, you must be double jabbed to attend this event. That seems to be the way it's going. Certainly anyone who's been on holiday will have had to fill in the passenger locator forms to come back, upload their data onto there. And I think that type of mindset is something that's going to come into employment situations as well. And so, yeah, I think it's going to be realistic that we see a contractual requirement for people to be double jabbed to accept work. Now, again, that's not with risk. The risks kind of touched upon again, but really need to reinforce the importance of data protection and GDPR. How is that data being sourced, stored, particularly in recruitment? If you have all these people applying for jobs and then they're all vaccinated, and then only one person gets the job, what are you going to do with all that information? How do you get rid of it carefully and all that? That needs to be thought about. Practical considerations as well. Are you going to miss out on the best candidate because they haven't got a vaccine? Does that actually help your business? There may be a policy decision to be taken on that, but you don't want to do yourself out of a good candidate, perhaps, without really considering all the options. So, say, for example, a company introduces a blanket contractual requirement policy for 2 jabs, then they want to employ someone who works from home, who hasn't got the vaccine, because of personal choice. Does that really matter? Perhaps not. So that's something that can be thought about. And obviously as well, it could take longer if you need people to be recruited quickly. Then is it going to delay the process further by having to literally check every person's had the jab and check that the forms that they've uploaded as proof are connected to the right person and all that? That's sort of practical considerations. And even in sectors, as I touched on at the start, we've got the care home situation on the 11th of November coming into full effect. There are still exceptions, and not everybody will get the jab because of their health or perhaps other reasons. And so that needs to be thought about because of the risk of some sort of discrimination or human rights claim. Our advice, is certainly heavily caveated with this is all very new, and we don't know how it's going to be viewed in the eyes of the tribunal. My personal view is I would be very surprised if the tribunals were critical of these types of approaches, because there's a public policy type issue, and I don't think employers should be put off by trying to encourage staff to get vaccinated. All I would say on this point, and the one to take away, is whilst yes, it can be done, I would certainly have any sort of contractual term heavily caveated with we will consider those who aren't vaccinated on a case-by-case basis, because if it does come to light they've got some sort of disability, which means that they can't have the vaccine, and you've completely disregarded them from the recruitment process, then obviously you would be looking at a potential discrimination claim, of which I think the defence would not be particularly attractive. So yeah, Can be done, but again,
Okay, great. It's back to you, Adam, actually, on this one. Again, another really good and interesting question. If a worker is not vaccinated, but has had COVID, has proven antibodies/immunity, but is refused work at a client's site or company, where does that sit legally?
Okay, so I think practically the situation could be perceived to be different because of the fact they've had it, and we're talking about the antibodies position. However, clinically, there isn't any evidence or I'm aware of that suggests that prevents future immunity and restricts transmission. So it doesn't really change the scenario. It is in essence the answer. It's the same as the situation before. Does the client have justification for prevent the worker who's not vaccinated from attending? And then what basis of that is that, looking at risk, etc., and the points we've covered off. The fact, though, it is a client poses the question. It depends on the scenario, and we assume that it's a placement at another site and the client is rejecting it. If the client is still insistent upon refusing a non-vaccinated person access to the site, then you've just got to be aware of discrimination claims is first and foremost, because again, the company, the employer and the company are potentially liable for the refusal to allow onto site. So what is the reason again for the non-vaccination, and look at that from a risk perspective, and then maybe put forward an exception to the policy on the grounds of those grounds, which is this is the rationale, and put that forward. If the employer, if the client is still refusing, then it's the same as a third-party pressure scenario, in my opinion, which is the client has turned around and said, I don't want this individual on site. As such, it's a potential SOSR termination because the client has put their foot down if an alternative post cannot be found. So the same as in a scenario, we do a lot of third-party pressure around theft scenarios where the client believes the person has stolen something, so it says, I don't want this person again on site. So you go through a process of investigation and plead on behalf of the client, of the individual, and if the decision isn't revoked, then essentially it's a dismissal on some other substantial reason, or SOSR.
Thanks, Adam. Sort of moving on now to sort of mandatory COVID testing in the workplace section we've got here. So question 7, and this one's to you, Paul. Can employers lawfully conduct temperature checks on employees, workers or visitors?
Yeah, so again, this is something that you may have experienced going to visit certain places, or certain workplaces have actually adopted this already, and particularly during the pandemic. Again, very much reiterating the government's rhetoric that it's good to get tested and keep everyone safe by getting tested, etc. And again, that's now spilling out into the workplace. But as we sort of hopefully move out of COVID, certain things are going to stick with us, and keeping tabs on whether people have got symptoms is, I think, is probably going to be one of them. Yes, you can take temperature checks. Yes, you can do COVID tests, and I think it's there's certainly no issue from that. I think the ICO state that as long as there is a good reason for doing so, employers should be able to carry out health testing on employees. Data protection law certainly does not prevent employers or businesses or any sort of company taking steps to keep their staff safe. So there's no harm in it. I think Adam touched on his response to the second question. The GDPR elements, and I don't want this to turn into a GDPR seminar, are important to consider. But if you're just taking people's temperature and that it's fine and there's no concerns, then I think there's no real need to store that information, and I probably would be advising against storing. I was going to say how hot people are on the day that they come in, but I'm not sure that's the right phrase. So yeah, that's really all I'd say. I mean, I think I think keeping tabs on people's COVID tests, again, if people are having a lateral flow to come to work, or you ask them to do it before they come to the place of work, and perhaps I don't really foresee a need to be keeping people's records of whether they tested positive. If they can just provide proof that they have tested positive, then I think, you know, within a reasonable time, I'd be recommending that that documentation is deleted, because I don't really foresee any long-term aims of or need to keep that information. Perhaps you could say, well, this demonstrates our response to COVID and how we monitored everybody, but certainly if you were keeping any information on how many tests you'd done, who'd been tested, it would be, I'd recommend that they were all anonymized.
Leads on really to the next question for yourself, Adam, and Paul, you just touched on it there within your answer. But can an employer require employees to take a COVID-19 test at work or before returning to work?
Yes, yes, I think you can, potentially. Again, potentially thrown in there. There's no legal requirement for staff to be tested. However, the government is strongly encouraging employers to sign up to regular testing to reduce the risk of transmission. That's also, I've had some clients though look at this and do testing, and their concerns are regarding the government pushing obligations onto private companies. Obviously, the cost, the time, the resources. So there's some clients have been looking at it, but quite negatively perceived by them because of the fact it puts everything back onto you as employers. The Welsh Government's also saying similar, encouraging testing, and also looking at putting in or facilitating testing with people who employ over 10 employees. So that's sort of the government stance on it. So, but how do you actually legally go about bringing this into place? And my thoughts are, if you're looking or potentially considering a mandatory vaccination policy, this might be the best place to start to gauge the workforce. Because again, with this sort of policy, I'd be advising on consultation, getting engagement from the staff, speaking to the rep, trade union reps and employees, etc., and seeing what their understanding is. So because this is a sort of halfway house between this and the mandatory step, essentially you can then pulse to see what the reaction is going to be and maybe see whether you can get support as to whether you want to do the secondary step, which is looking at the mandatory position. If you're going to go to staff, then look at how testing could be carried out, how staff would get the test results, the process of following if someone tests positive, if the level of pay, if someone needs to self-isolate but cannot work from home, so what's the situation, how someone's absence would be recorded if they need to take time off work, how testing data will be used, so again the data protection issue that Paul's touched upon. Any decision after the discussion should be in writing, and if staff, this is just following some of the points put forward by ACAS, and reassuring that if staff are tested, they need to still follow COVID guidance. So again, just because they've been tested doesn't mean they can stop putting in place the measures that are still in place. Again, that it doesn't vary depending on testing or vaccination. So that puts some of the issues forward. Again, they're considering some of the issues that you're going to be faced with. Some employers will see it as an invasion of their privacy, and the process is unwarranted. I think the issue you're going to have here is if you're going to be putting in this type of policy, then everybody's got to understand transparent situation and the transparency around what's going to happen if they test and they have COVID, and what's the situation if people refuse testing. So are you then going to put forward a disciplinary process and dismiss for failing to follow a reasonable management instruction, at which point that policy will be tested and will need to be sufficiently robust to defend a claim for unfair dismissal. So again, it hinges off what's the justification for it. And if you've got the support of the workforce, I think it's going to be far easier to justify that, fall off the back of the consultation process.
Okay, brilliant, thank you. The next section, it's section I've been asked this question myself a few times and had discussions on, sick pay as a result of COVID-19. So question to yourself, Paul, can an employer withhold sick pay for an employee who refuses to be vaccinated?
Well, there's two answers to that question. If we're talking about statutory sick pay, then the answer is no. An employer cannot withhold statutory sick pay from an employee who has refused the vaccine and then as a result been sick because they've contracted COVID. If we're looking, and that that's not going to change. You can't say the reason, depending on whatever reason you're sick, that depends on whether you're entitled to SSP. That's never going to change. That's not going to happen. So the question, I think, really stems more around contractual sick pay and whether the contract can provide for a mandatory vaccine to entitle, the person to be double jabbed, and therefore, if they are double jabbed, then they would be entitled to contractual sick pay if they got COVID. The Morrison's supermarkets have taken the stance that they will not be paying staff their contractual sick pay entitlements if they get COVID, if they haven't had 2 jabs. I don't know how that'll play out. I think it's a bit of a risky approach, I have to say. But these types of organisations are often the ones with a lot of say, a lot of influence, and perhaps that may filter its way through to other sectors as we live in this post-COVID world. I think for anyone who does not have that in their contract, so I expect nearly everybody, then it would be pretty risky to deny somebody their contractual sick pay entitlement if they got COVID and they hadn't been double jabbed. However, if you had introduced a change to their contract in relation to sick pay, or if you indeed had offered a new job to somebody with a new contract, then I don't actually see any issue with having that contractual clause in the contract and only paying them contractual sick pay, so basically full pay in the event that that person gets COVID. So that's pretty much it. I think you may, some employers, maybe this is Morrison's are coming from the point of view, you may have seen in current employment contracts these clauses around if you do skydiving or extreme BMXing or something at the weekend and you regularly find yourself with broken arms or broken legs, you won't be entitled to contractual sick pay because your activity that you're doing your free time are deemed to be dangerous. You're not saying to the employee that you're stopping them doing those things. You're just saying if you injure yourself and can't come to work, we're not going to pay you full pay because effectively it's your decision to put yourself in those situations. That could actually be a comparator drawn to being not vaccinated. I'm not really convinced that that's the way to go. To be honest, you could try and rely on it, but I would be cautiously advising on that one, shall we say? So, yeah, I think it is something we're going to see as we see new employment contracts and contracts adapt to COVID. I say again, none of this has been challenged yet. It will be a while before we see these types of situations being determined in the tribunal. But at the end of the day, if the employee has signed a contract to say they've been, that they understand that if they haven't been double jabbed, they won't get contractual sick pay if they get coronavirus, then I don't really see why an employer should be criticised for that, provided, of course, it's been caveated and it's case by case considerations made for those who might be disabled.
Thanks, Paul. Adam, for yourself, what are employees entitled to be paid if they suffer side effects from the vaccine and are unfit to attend work?
Essentially, usual sick pay policy applies. So if it's SSP, they'll get paid SSP. If they qualify in the company sick pay scheme, they'll get a company sick pay scheme. A lot of companies, though, are trying to encourage people to take up the vaccine. So they put in place a positive obligation for anybody who gets side effects will be paid full pay. That may be a situation whereby they usually get SSP. So therefore, it's not seen as a deterrent from having the vaccine, which has been some of the feedback from companies saying their employees didn't want to take it because of the risk of being ill and losing pay as a result. So it's been a positive measure. ACAS did a survey saying that 50% of employees that they surveyed had taken this up and offered normal pay to people taking the vaccine. So yeah, it's one of the measures. People are also looking at bonuses and other things to incentivise it.
Okay. Back to yourself, Paul. So Are employers able to incorporate COVID-19 absence as a trigger point for attendance review?
Well, I think the crux of this is there's no reason why you can't. I don't even think that policies, etc., would need to be amended to reflect COVID absence as being a trigger point. Whether it's actually trigger points are always something that it's not really a word I like in these types of situations, because I think every case of any sort of absence management capability process needs to be considered case by case, and often there is no trigger point. It's just a sort of evolution over a period of time as to what point the employer decides to commence or even end a capability process. When Adam and I chatted about this one, Adam's view was absolutely no problem, carry on. No reason why you couldn't just sack someone because they've tipped or had too much time off, and that sort of COVID was the final straw after a variety of absence reasons. Obviously very cautious on discrimination on that point, which Adam would be. But my view was almost, if you've had someone who perhaps had a bad back or broke their leg and then came back to work and unfortunately got COVID, it would seem a little bit harsh, bearing in mind that hopefully people are, able to recover from COVID, particularly if they've been jabbed now. So remember at all times, the unfair dismissal test would go to reasonableness. And so, if, as I say, you've had someone who's had an injury type absence, who's then come back and then perhaps been off for say 3 or 4 months, and then just by real bad luck they got COVID just at the time they were due to come back, I think would that be reasonable? Because most people's COVID symptoms might last for 5 to 10 days and then they can make a full recovery. And so would that be, well, I think I'd be probably saying no. So just be cautious. There's no reason, but if it really is a final straw, then yeah, there's no reason why it can't be used.
Yeah, it'd be harsh, but I think the trigger points are always there, aren't they, to actually have that conversation and to discuss it in the situation. So yeah, we had an interesting debate on that, I think.
So much nicer.
I thought you were going to just jump back on the fence then, Adam, but
oh, no.
At last.
Yeah.
Wasn't sure there. You came back on. I thought, oh, here we go. He's been convinced.
No, you can get away with really harsh policies as long as the policies are clearly communicated and justifiable. So
there you go. There's the answer.
I think I've been told I've been mean many a time in tribunal, but we got it over the line. So.
Fair enough. Next one for yourself then, Adam, actually. What is an employee entitled to be paid if they refuse to be vaccinated?
Unfortunately, this is a knotty one. Okay, so from the 16th of August, fully vaccinated employees will no longer have to self-isolate if they are identified as a close contact with someone with COVID-19. Okay. Employees who refuse to be vaccinated will be significantly more at risk of having to self-isolate. However, as Paul has said, if they obtain COVID symptoms and they go off sick, then they're entitled to SSP. However, in this situation, I think what the nub of the issue we're trying to ask is, what happens if we refuse them entry to site? So what is the situation? So we say we require you to be vaccinated. You haven't been vaccinated. You refuse to be vaccinated. And as such, what do we pay you whilst you sit at home? And the issue, firstly, is that you have a contract of employment in place that usually says we're contracted to pay you for 28 hours, 40 hours a week. And as such, you're not adhering to that contract by not providing with work. It's unlikely that you'd be able to rely upon what's deemed as a statutory medical suspension term, which is quite a complicated test and it very rarely applies. So that would be it wouldn't be a scenario that would apply. So therefore, because you're not adhering to the terms of the contract, you're at risk of a breach of contract by not paying them. So my opinion is you'd be obligated to pay the member of staff whilst you deal with the situation and try to look at the scenarios. So then what is a scenario but which the scenario then that would apply? Well, we don't want this person to be sat at home on full pay constantly. So what are we going to do with this individual? Do we either find a position to get them back? Do we find a scenario where they can come back into the office? And that would seem unlikely if they're not vaccinated, unless you can obviously get them to work from home. If they are off sick, if they are on full pay, then what do we do with them? Have we got justification for saying, well, you failed to follow a reasonable management instruction by not being vaccinated and dismiss them, which is one option and poses the risk we discussed before. If there's a scenario whereby they're not vaccinated on health grounds, or then you deem it to be justifiable to enforce that policy, irrespective of the fact they may be vulnerable, which I think would be high risk for discrimination purposes and obviously consider it on facts, then we'd have to look at what's known as a capability termination. So what's the medical evidence? What's the situation? Can we justify termination on that basis? I think, so in answer to the question, I think you'd have to pay full pay because of these scenarios, but you'd have to try and have a plan on a way out. So if the situation was to arise and you were to suspend them, what you don't want to be doing is have them suspended indefinitely for 2 years, a year, which sometimes happens, particularly in the public sector. So I think when you're considering this sort of policy and this sort of issue that may arise, you've got to consider what you're going to do in the circumstances and how you would deal with it in the situation to ensure that you've not got this person stuck on full pay sick pay. If you didn't pay them, there's a risk of constructive and unfair dismissal claims and breach of contract. So getting a clear route through it. Obviously, also other things to consider when looking at this is what would be reasonable adjustments depending upon if they've got a disability. Is there potential claims for discrimination arising from as well? So it's a real knotty issue.
Okay, so it's a really knotty issue. Thanks, Adam. We move into another knotty issue in some respects. So GDPR considerations. So a question for yourself, Paul. Can employers ask employees and workers if they have been vaccinated? And can they keep a record of which employees they have been vaccinated? Have you got that?
Yes is the answer. You can ask, and I don't think. Well, I think like to think that
we don't want to caveat that.
But I'm about to caveat. Yeah, I'm not going to say yes. Next question. So I'd like to think most people are actually quite pleased to tell you they've been vaccinated and don't have any qualms in holding back that information. Some people may say, what's it got to do with you? I'll touch on that in a slightly different question a little bit later. But in terms of the GDPR, obviously as employers, we have the right to hold personal data and indeed sensitive personal data of our employees. That is necessary to allow us to save them, make sure they're safe, and manage them, I suppose, effectively. And obviously, you'll be familiar under the GDPR of the lawful basis for processing that information. Now, the reasons why, and if you are looking at what if an employee asks you why they need to know, why you need to know, sorry, if as their employer, if they've had the jab. 3 reasons really. One, to track staff vaccination levels, so you can assess the risk of transmission within the workplace. Well, there is some doubt, as we know, whether the vaccine actually mitigates the risk of transmission, as I touched on earlier. Also, you may want to look at whether, if you have got these sort of incentive schemes, talking about contractual sick pay, one, if you've been double jabbed, then how do you know if someone's eligible for that or not? And obviously to ensure that statutory requirements are met. So those are, dealing with requirements to self-isolate if they're coming back from holiday or things like that. So yeah, that the real crux of it is yes, I think in terms of sort of tips on what to consider, is it time to get your those privacy notices out that you probably have drafted in 2018 and not been changed since, to look at COVID and whether we need to look at updating our privacy notices and data protection policies to reflect COVID and what we need to, our requirements as employers, certainly. But yeah, you can do it, and as I say, I think most people are willing to provide that information. Just obviously, I think it would probably fall into the sensitive information definition under GDPR, and so make sure that you are complying with your requirements for processing sensitive information, and keep it safe, and only keep it for as long as you need. So if somebody leaves, don't just keep their file and their COVID records indefinitely. Make sure it's compliant with your policy, and after a reasonable period, you get rid of it.
Okay, thank you. Adam, what could a legitimate interest from a GDPR perspective, what could be a legitimate interest from a GDPR perspective?
Yes, sorry, I was expecting two parts to that. The question I have. So a legitimate interest is obviously needed in order to process the data. Just quite simply, so provide a safe working environment or protect health and safety of staff could quite easily be a legitimate interest. Because of the fact we believe that taking information about vaccination and things is likely to be a special category data, then you've also got another obligation to ensure that it's not just it being a legitimate interest, but met the Article 9 conditions. So is it on the basis of performance of a right or health purposes is the other thing you need to think about from the GDPR perspective. If you've got justification for having it, it shouldn't really be a problem for the legitimate purpose test. It's just not having it's not being, well, I want this information just in case. I want this. There's not really a risk. We don't really think there's a problem because of the workplace we have and the scenario we have, but we just want it. Then that would be a circumstance that wouldn't be applicable. So simply, yes, we can get legitimate interest, but it's applicable to the risk assessment and the circumstances, the same with everything we've discussed today.
Thank you, Adam. I like the fact you're not sticking on the fence on that one either. Read in with a yes. Question 15. So to Paul, if an employee isn't vaccinated, what additional questions can you reasonably be asked to understand their choice?
Yeah, we had a bit of a chat about this one, Adam and I, this morning. I think the guidance from the government is obviously to recommend that people get the jab, and I don't think there's any harm in employers having a similar view and take on board that guidance. If they can present it to the staff in a positive way, and show the staff that it's the company stance that we want people to be double jabbed, and explain the benefits of that, and kind of go with a kind of educational kind of angle to try and show that people should get vaccinated and the positives of that, and why it might help keep people safe at work, reduce sickness periods, and we all know the benefits, and certainly Adam and I we don't need to tell you them here today. So that would be my suggested approach initially in terms of what type of questions asked. Go with we think it's a good idea, and invite them to tell you if they've had it. As I say, most people seem to be willing to say that they've had it. The difficulty is people who say, no, I haven't had it because I don't agree with it. No, I haven't had it because X, Y, and Z reason, or no, I haven't had it, but even if I'd had it, I'm not telling you. They're the kind of three situations that we're going to come across. In that situation, I think it would be probably going back to kind of if you've managed to extract, the percentage of the workforce who have been vaccinated, and then based on that information that you managed to obtain, are you then able to then conduct a more accurate risk assessment based on obtaining that information? Look at that, and then say, we either want to go for a no jab policy, or whatever, based on the risk assessment that you've managed to conduct. Yeah. So I think, I've touched on the data protection points, concerns. I think if you do ask the question and just ask them straight out, and then people say no, and then you just assume that because they've said no, then that requires no further information, then they may end up suffering some sort of detriment as a result of their answer just being no. I think that would be a little bit not the best idea, I don't think. I think, just you can ask the question, be reasonable, try and give people the information to why you think it's a good idea. If people are pushing back on it, then you may need to go beyond the reasons or beyond the answer of no and find out why exactly they don't want to have it. Now, if it's a case that they just say, I don't want it, I don't trust it or whatever, then you may take a decision as a business that that's not appropriate for that person to be in the workplace. But obviously, if they then say, I've got these conditions which mean I can't take it, or I'm pregnant and I don't want to take it at the moment, but I will take it once I've given birth, then those types of things that would certainly need to be explored. So I think just be reasonable, be understanding, try and promote information and give it to the employees, even if it's, you may want to set out both sides of the argument and then conclude as to why you still think it's a good idea. It is. There's no real right way or wrong way of doing it, but I just wouldn't, as we keep saying, nail it close to the mast and stick with it. I think you need to bear in mind all considerations, and let's probably go back to sitting on the fence.
It follows on really well, because I'm pretty sure a lot of people would have moved on to being asked this as well. But can an employer share information related to COVID-19 sickness? That's yourself, Adam.
So yeah, I mean, information, as I said, is about his special personal data, special category, and you can't share other people's health information with everyone. But I think you can take a reasonable approach. Obviously, the nature of COVID has been, and we've all kind of been educated about it in far as, have you been in contact with someone who's had COVID? Well, if you work in a 3-person office or a 5-person office and the person you've been in contact with isn't there, then it might not be too difficult to sort of work out who has got it. But yeah, just be conscious of people's personal information. I think the NHS seems to be, you've been in contact with someone who has had COVID. They don't tell you who it is, but most people are able to work it out, or even, they find out through another means because it's a friend or a family member or whatever. But yeah, just be respectful and understanding and knowledgeable of the special category requirements, and stick with that.
Skipped ahead slightly there. Back to you, Adam, on this one. But does an employee have the right to be notified if a colleague refuses to be vaccinated?
To keep satisfying you, Gary, no. No, I don't. On the whole, I don't think they do. You can tell the staff whether the whole workforce has been vaccinated and say whether the people are yet to, there is a certain percentage or generic information around the percentage of people haven't been vaccinated. But with regarding a specific individual, again, we go back to the data. If you were to be able to justify disclosing that information, there'd have to be a legitimate reason for doing so, and it must be justifiable. So I think it would be a very specific situation that would enable you to do that. That might be a scenario, possibly a very vulnerable person, but obviously the fact somebody is vulnerable doesn't change the situation regarding risk assessment, because obviously the risk assessment must obviously COVID secure place of work, distancing, etc., and those mechanisms. So if those measures are in place, then I can't understand why they would be entitled to have that information. Paul, can you think of anything whereby you've been entitled to disclose it?
No.
We've been discussing this. I think if anybody can, it'd be interesting. But yeah, no, I don't think there would be much basis for which to enable somebody to specifically ask that question.
Okay, we're sort of moving into the sort of last 5 minutes of the official timing, just gents. But Another question for yourself, Adam, actually, so it leads on really. But what happens if you have employees or workers who are refusing to get vaccinated and high-risk staff who are feeling at risk coming to work? Can you enforce the rules either way? That would be to yourself, Adam.
Yeah, sorry.
You were thinking, sorry.
Yeah, I was saying, I think the situation with it is the situation with the high-risk individuals, are they're no longer being forced to shield. Okay, so there's the situation where those employees have to go back into the workforce. So again, it's a balancing act, and again, it's a policy thing depending on your working environment as to what is appropriate in the situation. So the fact you have vulnerable individuals means that they obviously want to ensure their safety and well-being. Can you obviously enable those individuals to work from home? Can you put in measures that would enable them, their risk and their scenario to be reduced? Have you put in place reasonable adjustments for that circumstances? And is the potential issues around that? Obviously, there is no government mandatory requirement for people to be vaccinated. So again, we look at what basis you would have to enforce upon a vaccination in a situation. So it's hugely fact sensitive. And it really depends on the working environment you have as to what measures you put in place and what would be justifiable. If you had a particularly vulnerable or aged workforce, then you may have far more justification in trying to justify vaccination or put in place some form of mandatory policy in place. Can you divvy up the workforce? Can you reduce risk by the nature of the environment they work within? So does the site facilitate dividing the workforce up? There's all sorts of scenarios there. But again, I think it's about justification, your specific circumstances, and then ensuring you have a clear policy and process in place to justify it.
Quite interesting. That's one of the things that a lot of the Premier League clubs are dealing with, because they want to be seen to be promoting the vaccine for the supporters to be able to use the game. But the players are saying that they want to get vaccinated. And I've read something this morning that the players are saying actually the Premier League is one of the worst rates for vaccinations of players in Europe. So it's a bit tricky for the clubs. So the clubs are facing those problems where they say, well, you've got to have the jab to come to the match, but you can't. The players that you're watching might not be willing to get vaccinated. Now, of course, we don't know who has been jabbed and who hasn't, but interesting quandary for a lot of the clubs.
Firstly, you can tell Liverpool won at the weekend because you have mentioned football about 10 times. Secondly, I think there's an interesting point though on whenever you raise the vaccination, the easy comeback is, well, prove it stops transmission. And that if you, I read a lot about it when it all came out, and proving that data is going to be one of the hardest things to do. They reckon there's a curve and there's a trend to it reducing transmission. But at the moment, they can't obtain that data to really justify it. So I think it's a real rock and a hard place with people refusing to be vaccinated off the back of, well, actually prove it's going to stop transmission. And how long is it going to last? You're all going to have to, everyone's going to have to be triple vaccinated in a few months' time anyway. So it's a real tricky area. And again, I'm going to not say knotty issue again.
I'm conscious of time.
Yeah, just do this last one, I think, Gary.
Okay, fair enough. The last question I've got here is, what protected characteristic, I can't get the word out, sorry. What protected characteristics could the employee's choice not to be vaccinated fall into? For example, beliefs, race, or sex? Yeah,
so we will be familiar with the protected characteristics under the Equality Act and effectively the reasons why, the grounds upon which people be discriminated against. There's a few, and I'm conscious of time, so I'm just going to kind of whiz through them here. Age, obviously, initially at the start of the vaccine rollout, it was old people who got vaccinated first, and could there be arguments that those who are younger shouldn't have put to a detriment because they were unable to get the vaccine as early as old people. I think we're now at a point where really that sort of ship has sailed, because most people who are, or most adults now, have had the opportunity to have 2 vaccines. So I can't really see age discrimination being a significant problem moving forwards. Disability is obviously the big one, so some couple of times a day. Need to be careful of disability and reasons why people might not be choosing to get the jab, and for similar reasons, pregnancy, maternity type discrimination. There is, and indeed respected medical views that people who are pregnant or undergoing IVF should not take the vaccine. It's a matter for the individuals to discuss with their doctors, but that's something to be conscious of as employers if we are considering these sort of contractual terms or policies. There is also potential concerns, I suppose is the right word, about fertility treatment and whether people are less likely to conceive because they've had the vaccine. Do we know? Certainly, I'm not in any position to give any medical advice on that. We don't know yet, and we're not going to know for a period of time. So yeah, religion is another one. There were concerns about whether there was any animal products in the jab. I think that's all been denied, but certain religions have said that they don't want to take it for that reason, and also just general religious belief that they may not take vaccines because of their beliefs. There is, of course, the anti-vaxxer stance, and that whether that could fall into a belief in itself that would entitle you not to be discriminated against. We saw the case last year about ethical vegan chap who was found to have, or it was found to be a protected characteristic that he was an ethical vegan. Anyone seeking to argue that the tribunal would have to prove that significant reasons for that belief and really show that it was the sort of way of life, would mean that they did not believe in the vaccine. It's not in the vegan case. It was very much an absolute way of life for the individual, and that's why it was held to be a characteristic. It wasn't just someone who had elected to be vegan for the purposes of diet. So
that's also relevant from the fact that I've had a client to one of their employees who rejected the vaccine on grounds that it derives from a fish, and they're a vegetarian. Okay. So again, that's another consideration that came up.
So yeah, so we'll have to see if that's challenged. I would be very surprised if the tribunal determined anti-vaxxers to have a protected characteristic.
I agree.
We will see.
I think there might be an interesting one on age in relation to the younger generation not taking up the vaccine because of unknown health consequences of the vaccine in future years, and whether whether people in the teens, etc., may refuse that, and that would detriment the group. But again, because there's less people within their teens or within that area, we're not yet to see it, and it's only just really starting to drip down the vaccination to that level. So I think that's possible.
There is a real element of sort of just going to have to see what happens. No one could ever predict what we've been through the last 2 years, and the law and the rights of workers is going to have to adapt to that, and we'll see where we are. I'll be interested in 5 years what's come out, what stays and what goes. It'll be interesting.
I never even heard of furlough 18 months ago, which is that's the reality of this. We're all learning this.
Yeah.
As you're all aware, because you will have done the same, but you actually had to react and implement. We had to figure it out and advise. So.
Yeah, it's been a bit of a quick learning curve, that one, isn't it? I think we're still learning. That is definitely the case. I don't know whether or not there's been any questions that have come through on the chat at all, or if there's any, through and open to anyone, if anybody wanted to ask a question.
No, it doesn't look like there's any questions. Obviously, if anyone would like to follow up with any sort of questions about specific circumstances, Adam and I, happy to, or ask you can drop us an email and we can have a chat, whatever. This has been recorded. And if anybody wants to watch it again, or perhaps pass it on to a colleague who hasn't been able to watch it today, we'll send the link out later.
Okay. In that case, I suppose we should wrap up from there. Just a big thank you to the team at GAP. Claire, Chrissy is also involved, Helen and Leanne in our marketing team. Just thank you very much for everything, getting everything involved, and Aaron Partners as well. Thank you very much for all your assistance and for leading today's call. Thank you.
Yeah, thank you very much for coming, everyone.
Great. Thanks all.
Bye.
Thanks.
Thank you.